Hello, everyone. This is Heidi Lane. I'm the legal director at the Connecticut Department of Labor. I'm going to be talking about the Connecticut new paid sick leave law, everything that businesses need to know about it. And this is a streamlined version of the webinar. The webinar we did on the 12th, September 12th, was 2.5 hours. And we thought, yeah, no one's going to want to listen to that. So this is going to be a streamlined version. There won't be interruptions with questions. I'm just going to be going through the PowerPoint. And I hope to hit a lot of the information that you have questions on. So to begin, the agenda is going to cover a lot of material. The paid sick leave is within the jurisdiction of the Department of Labor, and it falls specifically within the Wage and Workplace Standards Division. They are the ones who investigate any complaints that come in. I'll discuss the complaint process later on in the webinar. But I just want to tell everyone that we have frequently asked questions on our website. We have the notice to employees. We've got the poster, and it's on Legal's website and Wage and Workplace Standard Division website. So we're going to cover these issues and more. Who is a covered employer? Who are family members? How do you accrue this sick leave? What documentation may the employer require? So we will cover these as we go. So the first thing is employer. So it's any person, firm, business, educational institution, nonprofit, corp, LLC, or other entity, including municipalities and the state. Now on 1/1/25, it's going to include employers who have 25 or more full-time and part-time employees in Connecticut. So those employers will be covered on 1/1/25. Anyone with 25 or more full-time and part-time employees. Now, the employers that have 50 or more employees are used to this because they've already been subject to it. So I want to also discuss what happens after 1/1/25. There is a phase-in. So on 1/1/26, employers with 11 or more full-time and part-time employees will be subject to the law. And the same with on 1/1/27, it's now going to apply to employers with 1 or more. So it's going to affect almost every employer in the state. So you would look at your payroll on 1/1/25 or 26 or 27, depending on when you're phasing in. And if you have that certain amount, if you reach 25 on 1/1/25, you are covered. If you have 11 or more on 1/1/26, you are a covered employer at that time. If you have 1 or more, you'll be covered on 1/1/27. Let's say on 1/1/26, you have 9 employees. You look at that payroll, and there are 9 employees on your payroll. You are not covered by the paid sick leave law until you look at your payroll the following January 1, 2027. Even if in March of 2026, you end up having 14 employees, if you didn't meet it on 1/1/26, you are not covered by the law yet. And that will be discussed a little bit more. So the number of employees is based on your payroll. So as we discussed, that's the payroll you look at. The payroll containing January 1st annually. So who are the exempt employers? As we've discussed, employers with fewer than the number of employees listed on the previous two slides. So because of the phase-in, you might not be covered until 2026 or 2027. There's another exemption, and that is for employers participating in a multi-employer health plan maintained pursuant to a collective bargaining agreement between a construction-related tradesperson employee org and the employers. We'll be able to define that a little bit more later. And also exempt are self-employed individuals. Are there any employees excluded from the law? Yes, there are. There are seasonal employees, but with seasonal employees, they may be covered if certain circumstances arise. So we will get to that. But that's important to know. They're not exempt completely. So individuals who are members of those construction-related tradesperson employee orgs, part of a multi-employer health plan, they are exempted from the law. So the construction-related tradesperson employee org refers to construction worker unions and their employers. I am assuming that the people who are involved in this or have these multi-employer plans, you know who you are. So they are exempt from the law. Here's what I meant when I said that an employee who works as a seasonal employee may be covered depending on the number of work days they have. So an employee who works 120 days or less in any year, and we're going to talk about the year period in a minute, and take a look at this is work days and not calendar days. So the seasonal employee has to have 120 work days, and it's their work days. If they work 4 hours a day, that's one day because that is their work day. We don't use a definition of day because we are referring to the seasonal employee's work day. So here are the issues with the seasonal employee definition. Here's one thing that I think employers need to be mindful of, and that's if you hire someone to work less than 120 days in a year, and they end up working more than 120 days. So what do you do in that circumstance? Because on day 121, that employee is no longer a seasonal employee. Because a seasonal employee is defined as an employee who works less than 120 work days in a year. So once they hit 121 days, work days, they are now entitled to what they should have accrued during the previous 120 days and be able to begin using paid sick leave. So I know this is a little complicated, but I think it's important to note that you may, for best practice, you may want to track the number of days they would have accrued beginning on 1/1/25 or whatever year you become subject to this law, because that will be the number of paid sick days that they would be entitled to use on day 121. So you may want to keep track, but the employee does not get to use the paid sick leave. So you may just want to keep track, but may not want the employee to see it, because they would not have access to it if they worked less than 120 days. So what are the reasons for leave? There are a number of them. The employee or their family member is ill, injured, or suffering from a health condition. And we will define what a family member is in a minute. The employee or their family member is obtaining a medical diagnosis or treatment. The employer or family member is seeking preventative medical care. A mental health wellness day. I'll explain the definition of that as well. Either the employer's place of business or a family member's school or place of care closes by order of a public official or due to a public health emergency. Similarly, a health authority, the employer or the employee's, the employer of the employee or the employee's family member determines that the person poses a risk to the health of others because of exposure to a communicable disease. So those are the reasons that someone can take leave under the paid sick leave law. So I can go to the next one. Here we go. Here's another category, and that's if the employee or their family member is a victim of family violence or sexual assault and they need time off, they will be able to use any accrued time for medical care, counseling, obtaining services, relocating, or participating in any judicial proceedings. So that is for the employee or their family member. There's a statute within the jurisdiction of the Department of Labor, which provides 12 days of unpaid leave for victims of family violence. Now that's for the victims. So the 12 unpaid days are in addition to any other leave. So employers are prohibited from requiring the employee to use those days concurrently with the paid sick leave. Those are two separate things, two separate entitlements. 12 unpaid days under the other statute, 31-51 SS, or the 40 hours of accrued paid sick leave time. They will not run, they should not run concurrently. So we know what the purposes are and the reasons for the leave. Can an employer take disciplinary action against an employee who utilizes the sick leave for a purpose other than those permitted under the law? And the answer is yes. It might be hard for an employer to find out what it was used for, but if they are using it for something that's not covered in the law, you treat them the way we treat anyone else who takes a day off and is not excused. Now, I said that Mental Health Wellness Day has a definition. And that is a day during which an employee attends to their emotional and psychological well-being in lieu of attending work. This is very broad. And if I choose to use my mental health wellness day to go to the beach, because that's where I will get my emotional well-being back, that is permissible under the law. So there are a lot of reasons that someone could use this, but it is a valid reason under the law. I want to define some of these categories of people that you can take time for using the paid sick leave. A family member is a spouse, sibling, child, grandparent, grandchild, parent of an employee, or an individual who is related to the employee by blood or by affinity, whose close association the employee can show to be equivalent, to a family relationship. This is very broad. For those of you, and it should be most of you, who are covered by Connecticut's FMLA, you have seen this language before. Because that language about affinity, whose close association is equivalent to that of a spouse, sibling, child, and so on. That language is in the FMLA. And although there were many, many discussions about this prior to the enactment of the CT-FMLA, there has not been one complaint received by us in the under the FMLA, and all the FMLA complaints would come to us, and we have not seen one questioning the close association that's equivalent to a family relationship. So I hope that that will not be a problem. Child is biological, adopted, foster, stepchild, legal ward, who is standing in, an employee who is standing in loco parentis, or an individual to whom the employee stood in loco parentis when the individual was a child. And the child can be of any age. In loco parentis merely means that someone stood in place of the parent, either when they were growing up, or your employee stood in loco parentis to a child in place of the parent. Grandchild, blood, marriage, adoption, foster care by a child of the grandparent. So it's interesting to see that this is by marriage as well. Parent includes a parent-in-law. And here we have, or a parent can also be someone who's standing in loco parentis. A sibling, brother or sister related by blood or marriage, adoption, or foster care. So it would include in-laws. And spouse is someone who's legally married to an employee under the laws of any state. If it's a marriage in one state, it's a marriage here. Common law marriage in Pennsylvania will be recognized here. So those are the major definitions that you need to know. Now I want to talk about the accrual. The accrual begins on 1/1/25, unless the employee was hired after that date. If hired after 1/1/25, the employee's paid sick time begins to accrue on the first date of employment. And this is the same timeline for the phase-in employers. Same thing for January 1, 26 and January 1, 27. The employees begin to accrue on that date or after that date on their first day of employment. So I want to talk about this because this is important. Each employer provides paid sick leave every year at a rate of 1 hour of paid sick leave for every 30 hours actually worked by the employee. And it says annually. What's a year under this law? It's any 365-day period that the employer uses. So if an employer wants to use a fiscal year, and maybe they begin their fiscal year on July 1st, they do need to begin to accrue. The employees need to begin to accrue on 1/1/25, but then the employer could restart the year on July 1st. So, but don't forget that you have to start the accrual on 1/1/25. And carryover is still applicable, and we'll get to carryover in a minute. And I'll also explain in a minute what happens to the employees who currently work for you. And it turns to 1/1/25. What do you do? I will explain that. Employees who are exempt from overtime are presumed to work 40 hours per week, but they're not going to accrue paid sick leave for any hours worked over 40. So if you have an employee who works 60 hours a week, generally, you are only going to count 40 hours as their work week. And those same employees who work less than 40 will simply accrue paid sick leave for the number of hours they normally work. If a salaried exempt individual works 30 hours a week, they will end up getting 1 hour for every 30 worked. And they will probably not get up to, I'm sorry, I take that back. You will just count the number of hours they normally work. Their normal work week would be 30 hours if they only work 30 hours a day. They can still accrue up to the 40, but you will count their work hours towards the accrual. An employee may begin to use accrued hours 120 calendar days after their date of hire. Before I mentioned the seasonal employee, they have to work 120 work days. But for employees who are not seasonal, they have to work 120 calendar days. This is a one-time requirement, and once it's met, doesn't have to be met again. 120 calendar days is 17.14 weeks. So what do you do with current employees? Or someone who's a newly covered employer with employees on 1/1/25. If that individual has worked 120 hours, 120 calendar days for their employer, they begin to accrue on 1/1/25, and they do not have to meet the 120 calendar days to use it. They've already met it previously. So they do not have to satisfy the 120 calendar day requirement in order to use paid sick leave if they have been employed with the employer longer than that time. So they will begin accruing on 1/1/25 or 1/1/26 or 1/1/27, depending upon your size. But employees who have worked for the employer already 120 calendar days will not have to wait an additional 120 days to use the time. Employees are required to allow employees to use accrued leave in 1 hour increments. Employees can't use it in lesser increments unless the employer approves it. Now, I know a lot of employers have policies that say you have to take time off, PTO, paid sick, in 4 hour increments. For paid sick leave, they have to be allowed to take paid sick leave in 1 hour increments. So that's something employers will have to check their policies on to see if they are in keeping with what's required under the law. What happens to the employee who doesn't use all of their 40 accrued hours in 1 year? So I can't stress this enough. Employees are entitled to accrue and use a maximum of 40 hours under the law per year. An employer doesn't have to provide more, but they have to let them accrue and use 40 hours of paid sick leave if they have accrued it. What happens the following year? Any hours that you have accrued in the current year and you haven't used them, they get carried over to the next year. So I think it's best if I give an example. I have accrued 40 hours of paid sick time. In 2025, I use 30. I have 10 accrued hours of unused sick days. I can carry that over into 2026. I start accruing again in 2026. So what do I use in 2026? I begin accruing immediately, but in 2026, I use 20 hours of sick time, 10 hours of which are from 2025, the previous year, because I carried over the 10 hours from 2025. What I do for 2027 is, because I used 10 hours from 2025 and 10 hours from 2026, because I used 20 hours in 2026, what do I carry over to 2027? I carry over 30 hours. Let's say I carried over the 10 hours from 2025 and didn't use any sick time in 2026. I accrued 40 hours in 2026. And I had the 10 that I had carried over from 2025. What can I carry over into 2027? Only the 40 from 2026. The 10 from 2025 dropped off at the end of 2026. Now, someone looking at this person's paid sick leave may see that in this latest example of not using any leave but carrying over 10, it looks like they have 50 hours of sick leave to use, but they don't. Not under the paid sick leave law. You accrue up to 40 and you use up to 40. That's all the law says. Now, there are options for the employer, but it's an option. It can be paid out if the employee does not use a certain amount of paid sick leave at the end of the year. That has to be with the employee's agreement. But in lieu of any carryover, employers may front load the amount of paid sick leave that the employee would be entitled to at the beginning of the new year. And by new year, it does not just mean January, it could be your 365-day year. So if you use a fiscal year of July 1st and you front load 40 hours for me, so I have 40 hours to use from July 1st on for the year, you don't have to worry about any carryover because you're giving me my full entitlement every year. So you do not need to worry about carrying over because you are giving me 40 hours every year, and that's what the law requires. Now, let's talk about what documentation is required. There is no documentation that an employer can require. They're actually prohibited from getting any documentation showing that their leave is being taken for a permitted purpose. So that's in the previous paid sick leave law that the employers with 50 or more employees were used to. After 3 days, you could get documentation. Now you cannot. No documentation may be required. You may need to know from them whether they are taking it for a reason under the paid sick leave law. So you can always ask them, is this one of the, are you taking this for a reason under the law? But there is really no documentation to be turned over. What's the employee notice? The law does not require the employee to provide their employer advance notice of their leave to use paid sick leave. However, the employer has some rights here. They still have a right to know whether an employee is working that day. And the employer may have a policy requesting that employees provide advance notice. However, if the employee does not follow the employer's policy for providing advance notice, they cannot enforce that part of the policy because no advance notice is required. That particular provision was taken out of the new law, was taken out of the previous law, and it does not appear in the new law permitting advance notice. However, you still have the right to know whether an employee is working that day. And if you have a policy that says you have to call in an hour before, then, and they don't, and they do not have a valid reason for not calling in the day before, then they may be violating your policy for calling in. What our position would be that the employee must give notice on the day of the absence as soon as practicable. I mean, if I wake up and I'm fine and I get ready and I'm on my way to work and all of a sudden I get a migraine, well, I couldn't follow the employer's policy on calling in 1 hour ahead of time because I didn't know I was going to be sick. So employers have to be a little careful about that. Now, what does an employer have to do? An employer has to display posters in English and Spanish. They have to provide written notice to each employee no later than either 1/1/25 or the employee's first day of employment. Employers with remote employees must either send the posters by email or publish the posters on a digital platform. Anyway, anything that the employee can see. And we have the posters and sample notice on our website, along with the FAQs and along with this webinar that will soon be posted and the PowerPoint. How about pay rate? The pay rate is generally the normal hourly wage for the employee, or the minimum fair wage under the statute in effect for the pay period during which the employee used the leave. And any employee who has a varied number of hours, the normal hourly wage is the average hourly wage in the pay period prior to the one in which the employee is using the paid leave. Employees who earn tip credit, because we all know it's lower than the minimum wage, they must be paid minimum wage for any paid sick leave hours used. And not included in the calculation of normal hourly wage is overtime and commissions. They're specifically exempted from the normal hourly wage. Break in service. Any termination of an employee's employment is a break in service. If someone is then rehired after this break, the employee loses any paid sick leave they have accrued, but retains the calendar days worked towards the 120 calendar days requirement. So, and they definitely have to begin to accrue sick leave again upon rehire, as long as they've worked the 120 calendar days, whether it was all prior to the break, or if it was prior to the break and then sometime when they are rehired, once they hit 120 calendar days, that is a one-time requirement. So let's say I quit in October. The employer hires me back in January. I have my 120 calendar days, but I don't have any hours that I have accrued. I start fresh with the accrual. My employer fired me. Am I entitled to pay out my accrued sick leave? The answer is no, unless the employer's policy, if you have a contract or a collective bargaining agreement, provides otherwise. But if it doesn't, then the employer does not have to pay out the accrued sick leave. Absent a policy, contract, or CBA. Now, an employer is in compliance with the law if they offer other paid leave that can be used for the reasons in the law, is accrued in total at a rate equal to or greater than the rate in the law. And other paid leave may be PTO, vacation, personal days. So let me give an example. An employer provides 3 weeks of PTO. So we know that's more generous than the paid sick leave law. And it can be used for anything, including sick time. So I go to Aruba for 2 weeks in February. So what do I have left? I've got 40 hours left. I've used 80 of my PTO because the employer gave me 3. And then I use 1 sick day. So even though they've used 80 hours of PTO on vacation and 8 hours for a sick day, until they reach their full 3 weeks of PTO, they may still take sick time. So there are 32 hours remaining of their 3 weeks of PTO, during which they could use it for sick days. So if you give 3 weeks of PTO, you are in compliance as long as I can use any of that time, either at the beginning, the middle, or the end, for paid sick leave without being penalized. So just because I used up 80 hours at the beginning in February to go to Aruba, that's not paid sick. I used it for vacation. I have time left. Now, if the employer gave me 3 weeks and I used all 3 on vacation throughout the year, and all of a sudden I'm sick, do I get more time? Not under the law, you don't, because you could have used any of those 3 weeks that you got. You could have used them for paid sick, but you didn't. The employer gave me the 3 weeks and I could have used it for paid sick. So as long as I don't get penalized for using any part of that 3 weeks, then the employer is in total compliance with the law. So what if your policy, what if your paid time off plan allows employees to accrue more than 40 hours of sick leave? Employers who allow more than 40, they can limit the use of additional hours over 40. So let's say your policy is that you cannot take a sick day for someone else's illness. Once I hit the 41st hour, I have to follow your policy. And I would only be able to use paid sick for myself. You can also apply your normal attendance and time off policy to any hour used over 40. You can require documentation before permitting the use of any hours over 40. But the 40 are the ones under the law. But you can decide what you want to happen on the 41st hour. My employer was bought out by a new company, and I am remaining employed with the new company. What happens to my sick leave? The law now says you retain and you can use all the paid sick leave that was accrued under the previous employer. It's as if they are a successor to the previous lawyer. Oh my goodness. It's as if they are a successor to the previous employer. They retain and can use all of their time. I'm still under the same employer, but I was transferred to a new division. What happens to my paid sick leave? Same thing. You retain and can use all the paid sick leave that was accrued or received at the previous division in Connecticut. Can there be a donation policy? An employer may voluntarily establish one, but they don't have to. If an employee donates paid sick leave, the employee no longer has that donated paid sick leave available for their own use because you've given it away. If you donate 8 hours, you no longer have those 8 hours. And such a policy is up to the employer. Can an employee choose to work additional hours during the same or following time period instead of using paid sick days? They can, but it has to be with the employer's permission. So don't just assume that you can do it. The employer has to approve it. Can an employer require employees to find a replacement to work their scheduled hours before they can use accrued paid sick leave? And I know some employers do require someone to find a replacement, but not if you're using time under the paid sick leave law. They're actually prohibited from requiring them to find replacements if they are using paid sick leave. What about if there is a collective bargaining agreement? The changes in the law cannot diminish the rights already granted in a CBA. The changes cannot override the terms of a CBA that was effective 1/1/2012 or July 1, 2012. The July 1, 2012 provision refers to collective bargaining for family child care providers and personal care attendants. So if these CBAs have not been renegotiated, then you can still use whatever provision is in the CBA. If they have been renegotiated, then the information in this law, the provisions in this law should be in any CBA. Now, how about record keeping? Employers have to track and keep records of hours worked and paid sick accrued. And that's just part of the normal record keeping obligations. You can do it electronically if the employee consents, and records must be securely, privately accessible to the employee. And the records must be kept for at least 3 years. Employers must give CTDOL access to the records for monitoring and compliance. If you don't provide reasonable access, it may result in a $100 civil penalty per violation. So it's just as with anything else, keep track of the time used, the hours accrued, the time used for paid sick, and you'll be all set. And if you have PTO instead, and you let them use PTO for any reason, just make sure you keep track. Now, no employer shall take retaliatory personnel action or discriminate against an employee because they request or use it, or they file a complaint with us. And retaliatory personnel action is generally some adverse employment action that's taken by an employer. There's some case law out there not related to paid sick, related to other laws. A written warning may not constitute retaliation, according to some cases. In other cases, it may. So you just have to pay attention to what you are doing. If something you are doing subsumes any of the paid sick leave accruals or use. Here's the complaint process. They file a complaint with the Workplace Standards Division. There's the forms on our website. The complaint will be investigated by that division, Wage and Workplace Standards. They will talk to the complainant, the employer. They'll look at employment records. As part of the process, we'll talk mediation to see if we can resolve it. And we have the discretion to determine whether the complaint will go to a hearing. If a hearing is held, we will hold a formal administrative hearing. And the parties can either engage a representative or represent themselves at any stage in the complaint process. After there's a formal administrative hearing, if the labor commissioner finds by a preponderance of the evidence that the employer has violated the act, the employer will be liable for civil penalties, including the civil penalty I mentioned. But the commissioner can also award the employee payment for used sick leave, reinstatement to the employee's previous position if they were terminated for the use of this, and payment of back wages. So if I use my 40 hours of paid sick and I get terminated because the employer thinks that I was out too long, if I prevail, I could get my job back and back pay. Commissioner can also reestablish any employee benefits that the employee would have received if there hadn't been a violation. And the commissioner's decision can be appealed to Superior Court. There is no private right of action otherwise. So here's the contact information for Wage and Workplace Standards Division and the Legal Division. And if you have questions, please take advantage of these contacts. And please take a look at our website, which has a lot of information concerning the paid sick leave law. And I think you'll find the FAQs and the other things that are up there helpful. So thank you very much.